We are very privileged to hear from two of Australia's preeminent barristers. If I might introduce Ruth Higgins SC first. She's a commercial and public law silk practicing nationally from Banco Chambers in Sydney. She's the president of the New South Wales Bar Association, a member of the Takeovers Panel, a fellow of the Australian Academy of Law, and an assistant general editor of the Australian Law Journal. She obtained a DPhil in legal philosophy from Balliol College at Oxford in 2001, subsequently published that work by Oxford University Press in 2004, the work entitled The Moral Limits of Law. Ruth has a diverse practice, including in administrative and constitutional law, commercial law, and equity, and frequently appears in all sorts of tribunals, but in particular, of course, the AAT. She's appeared at various inquiries, including the Special Commission of Inquiry into the Ruby Princess, the Banking Royal Commission, and the Independent Liquor and Gaming Authority's inquiry into Crown Casino. So welcome, Ruth. Tom Brennan SC, through a long career in public law, policy and administration, predominantly in the Commonwealth jurisdiction, has deep expertise in merits and judicial review and practical understanding of the functioning of government agencies, understanding the enormous good which government does for individuals, families, communities, and regions, and the great difficulty and harm which the exercise of government power can inflict. Tom was the founder of the Welfare Rights and Legal Centre in Canberra, co-author of the first 3 editions of the Annotated Social Security Act of 1947, a research officer on the Access to Administrative Justice project at the ARC, ministerial advisor to the Honourable Brian Howe MP as Minister for Social Security from 1986 to 1990, during which time he advised on the establishment of the SSAT as the first-tier determinative merits review body on the rewriting of the Social Security Act. He appeared for Justin Warren in the AAT and in the full court on a matter, an FOI matter concerning access to the robo-debt cabinet submissions, upon which the full court remains reserved. He is briefed to advise and appear for certain individuals who may claim damages for personal injury done to them by reason of the implementation of the robo-debt scheme. So today, Ruth will address the role of the advocate in administrative decision-making, and Tom will speak on the tensions between facilitating merits and the ambit of administrative discretion. Tom and Ruth, over to you.
Thanks very much, John. I've provided a written paper which I won't speak to, but what I wanted to do was to focus on a few of the aspects of robo-debt and to look at what the ART might and might not do for it, but also in that to look at some of the aspects of social security appeals and the way that some of the issues that I suspect may arise as we move into the ART era. In framing that, I want to start by identifying what the Royal Commission identified as the root cause of robo-debt, because it's got nothing to do with administrative law, and it's got to do with what, in my experience, which was a long time ago, but was reasonably extensive in government, was truly extraordinary conduct. I don't think there is an occasion like it in the history of the Commonwealth, of serious misbehaviour at the apex of government. So the Royal Commission found that the robo-debt scheme was implemented as a system as the result of a submission made to the Cabinet by the then Minister for Social Services, Mr Morrison, which depended upon a recommendation, the effect of which would be the introduction of averaging of income as the basis for raising debts, where no reader of the document could tell that what was proposed was the averaging of income. Mr Morrison knew that that was the effect of the proposal if it was to be implemented, and he knew that no one reading the document he was putting to his own cabinet could tell that that was the proposal. The Royal Commission found that Mr Morrison knew that a few weeks before he had been advised that that proposal would require legislative change if it were to be implemented. He knew that the proposal he put to the Cabinet said the opposite, and he knew that he had no reason whatever for not telling the Cabinet that legislation was required and instead telling them the opposite. He gave a reason to the Royal Commission which the Royal Commission rejected as untrue. So the starting point, I think, for analysing responses to robo-debt is to understand just how serious the conduct was which resulted in it being introduced, which was a deliberate misleading of Cabinet, supported by the Secretary of the Department, where the Royal Commission found the Secretary knew of the misleading effect of the new policy proposal, but chose to stay silent, knowing that Mr Morrison wanted to pursue the proposal and that the government could not achieve the savings which the NPP promised without income averaging. So you have a Secretary and a Minister making deliberate, knowing choices to mislead the apex of the executive government to introduce a program to harm hundreds of thousands of people. So when it comes then to assessing what the administrative law system does in response to that, the Royal Commission in chapter 20 then went on to look at what the AAT did, and 220 times the Tier 1 AAT made findings that the conduct in individual cases was necessarily illegal. 5 of those were by Terry Carney, who on any view was the eminence grise in social security law in the country. He published shortly after he wasn't reappointed an article which I've quoted the 3 key points, goes for less than half a page, sets out in 3 very clear propositions why that conclusion must have been the case. But the department gamed the system such that the lawyers dealing with the appeals agreed with what the AAT was saying, knew it was right, didn't appeal them, and buried them, while the senior executives of the department maintained a public position of the opposite, that what the AAT was saying was wrong, that there was no question as to legality, and on they charged. Now, when testing all of that, I can be rather more cynical than the President. Well, I am more cynical than the President. Alternatively, I'm entitled to publicly express more cynical views than the President ever could. But for the life of me, I can't see how, if there were a risk of publication of AAT decisions, robo-debt would ever have been implemented. And when you track through the history, what is stark is that but for the abolition of the SSAT on the 1st of July 2015 and it being rolled into the AAT, there would have been publication of the fact of the illegality. So the 1st of July 2015 was the first day of implementation of the robo-debt scheme. It also happened to be the first day where the SSAT didn't exist, and so there was no national convener of the SSAT with a relationship with the Minister for Social Services, with a statutorily mandated relationship with the Secretary of the Department of Social Services, and with a power to report annually, not as the AAT's power is, only to report on administrative operations, but rather a power to report on the operations of the tribunal. a power which had been exercised by the SSAT, as it is by most of the state equivalent general review tribunals, by a chapter in each annual report of decisions of significance. So I think there's almost no question that but for the flawed amalgamation in 2015, robo-debt would not have proceeded, and would not have proceeded because the Secretary, who was no fool and who set up a game which worked for 4 years, the Secretary would have known the game could not have been pulled off but for the amalgamation into the AAT in 2015. So that when you then look at what's proposed by way of the power to publish decisions of significance under the ART and the Guidance and Appeals Panel, in my view, it's more than likely that if they had been included in the 2015 amalgamating legislation, robo-debt probably would not have happened. So it probably does not become so much one, as the President must address it, of, well, if such a thing happened again, we'd have some powers which may be able to be usefully exercised. That's not the way, in my experience, Commonwealth administration works. These things are gamed and worked through in detail. I was head of a legal branch of one of the major administrative law litigators for about 18 months. Me and my staff were tasked with all sorts of exercises by various senior people to work out ways in which we might, one way or another, impede the system of administrative review. So I commenced by that observation, and I think very importantly, as part of that, to observe the AAT Tier 1 through robo-debt did exactly what it was established to do. It provided accessible, accurate review of individual cases according to law. It was not set up to do anything more than that. Having made that observation, I wanted then to go to some of the other aspects of social security decision making, to say, in effect, we mustn't lose sight of the rather important aspects of what was Tier 1 social security decision making, which was to have a quick, accessible, informal review for people who, when they need it, are either facing extreme financial hardship or indeed have no income and no financial resources at all. So that probably of all of the things that the legal system engages with, they are people who have a need for very quick decision making. I wanted to focus upon the history of the contributions of the Whitlam Government to all of that and the way it's played out, to show that I think while what the President speaks of by way of the reforms which will enable a more coherent, sensible management of the ART internally are to be welcomed, there's a real risk in losing sight of, first of all, the need for review to be closely integrated with the individual agencies whose decisions are being reviewed, and secondly, for that integration to be designed with a level of cynicism closer to mine than to the President's. And so, starting with the Whitlam Government, the Whitlam Government's contributions in this area were twofold rather than one. Not only was it the enactment by Kep Enderby of the AAT Act, It was also the establishment by Bill Hayden of the Social Security Appeals Tribunals, which were established about 3 weeks before MDB introduced the AAT Act. The Social Security Appeals Tribunals were really quite an interesting innovation in Australian public administration because they were driven very much out of a design not of a merits review system, but of trying to get to an ideal system of social security decision making. And so they were multi-member. There was a lawyer, a social worker or community worker. For a while there was a seconded departmental officer, and then in invalid pension, which became disability support pension cases, a medical officer. The department was prohibited from appearing. They met in private. They had meetings rather than hearings. The meetings were structured essentially as seeking to get a high quality conversation with the applicant, all directed to trying to overcome the range of what Matthew Groves has recently called an inequality of arms. That is, where the individual who has just their one case is always up against it when they're fighting the government, which runs thousands and thousands of the same case. And so there were features of the design by Hayden of the Social Security Appeals Tribunal which were directed at trying to enable the individual to be able to engage directly with the Appeals Tribunal and get as best a decision as they could, and for the Tribunal to have the set of skills through its multi-member membership, which would mean that that was more likely than not to happen in the majority of cases. The Social Security Appeals Tribunals, once created, seemed to work very well by all accounts, but always had a problem of a terrible backlog. So in the first 3 weeks of their existence, they received some 18,000 appeals, and they never got over that backlog. Now that becomes rather important when we go to the history. My first engagement in government was when I was appointed by Howe to start overseeing from the political office the process which he as Minister for Social Security was conducting following an Administrative Review Council report which had recommended that the SSATs be given statutory life and determinative power. And the first thing that he announced was approval in principle, agreement in principle, but we wouldn't be doing it. Rather, we would be focusing first of all on getting the authorised review officer function fixed up. And this goes to my point about cynicism. What we discovered, so my first job with him was to oversee the fixing up the authorised review officers. And effectively, there was no system for authorised review officers in the Department of Social Security. And so it varied all across the country, but essentially if you sought a review by a review officer, the first thing people did was try to find the papers, who had the papers. And generally there was a process of going back and forth between the review officer and different bits of the department trying to pull together the papers. And that could take months and months. And then eventually a decision would be made. And then if there was an application to the SSAT, then there'd be a further process by a different bit of the department trying to check whether that's all the papers or whether there are more papers. And it took quite a long time, but we eventually designed a system which varied a bit depending on benefit and pension and so forth, but where if there was a request for a review officer assessment, then there was a structured process with timelines for the papers to be got together by the relevant areas, put into one file and presented to the review officer. So that there was a review file off which the review officer would make a decision. And then if there was an application to the SSAT, what would go to the SSAT was the review officer's decision with the file that had been created before the review officer looked at it. That then meant when we came to legislate the SSATs in 1988, we could build in quite tight timeframes for requirements for the department to deliver papers to the SSAT. And that worked very well. Importantly, in part of that context, we included a number of interesting provisions in the Social Security Act, but the first was Section 176, which I've reproduced in the paper. I still remain rather proud of it because I can remember having the arguments with Lindsay Curtis in the Attorney General's Department about its wording, but it's become the template for civil litigation purpose clauses around the country. It was first introduced in the Social Security Act. So it read, the Social Security Appeals Tribunal shall, in carrying out its functions under this Act, pursue the objective of providing a mechanism of review that is fair, just, economical, informal and quick. And that of course then became effectively in 2015 Section 2A of the AAT Act and is currently Clause 9 of the ART Bill. Slightly different wording but same propositions. But more importantly was in my view then was Section 193, because 176 was, as those provisions I've just referred to, Section 2A now or Clause 9, was limited to the objects of a mechanism of review. Did not engage directly with the exercise of power and discretion as to the conduct of an application for review. That was, and so for the Social Security Appeals Tribunal, that was Section 193, which said in reviewing a decision, the tribunal is not bound by technicalities, legal forms and rules of evidence, then most importantly, shall act as speedily as a proper consideration of the review allows, and C, shall, in determining what a proper consideration of the review requires, have regard to the objective laid down by Section 176. Now, all I can tell you, because I ended up going off with Howard and to health and other things, I never returned to Social Security, and the SSAT decisions aren't published, so I don't know. But what I can tell you about what those of us who drafted that intended it to do was this, that the department in providing papers and other materials to the tribunal was engaged as part of the mechanism of review. The Act itself prescribed that the department would do things and the tribunal would get those things from the department. So that if there were delay on the department side, the tribunal would be entitled, in considering what a proper consideration of the review requires, to have regard to the timelines that the department was permitted and say, well, if you've had that amount of time, department, that's all you need for proper consideration. I then have to act as speedily as is consistent with those timelines. Whereas if the applicant for review needed to go and get examined by a doctor, well, a proper consideration of the review would require time for that to be done. So that 193 was enacted expressly by those of us drafting this to address the inequality of arms of the individual. Say, well, but also from the cynical perspective of recognising there would be ministers and there would be secretaries come after us who would see the opportunity of gaming the system by not resourcing review officers, by changing the system for getting papers together, for otherwise imposing delays, where without a provision like Section 193, the tribunal would end up with its hands tied when the department comes along and says, oh, well, you know, we need to have a Commonwealth Medical Officer's report and we can't get the Commonwealth Medical Officer appointment for another 5 months. The tribunal would not be in the position that Section 193 provided for it. Now, all I can say of the performance of that legislation was timeliness was fixed. So the backlog that I spoke of from the start of the SSATs carried through till 1988. By 1990, the timeline had come down from, average timeline from lodgement to decision had come down from about 17 weeks to 8 weeks. It was held at 8 weeks all the way through to 2015. In 2015, with the amalgamation legislation, consistent with the Better Decisions report of the ARC, the objects of the mechanisms of review from Section 176 were added into the AAT Act as the objects of the AAT in Section 2A. But Section 193 and its equivalent was omitted, and instead the general AAT provision governing the conduct of proceedings in the tribunal, Section 33, governs Social Security reviews. Now, since then, the average time for Social Security reviews has blown out from a little less than 8 weeks to a bit more than 11 weeks. I can't say that there's a causal link between the two. All I can say is one of the bits of armour which prevented a department from gaming the review system and causing delay was dropped off in 2015, and there has been a 40% blowout in processing time since. Now, there might be all sorts of other reasons for it. I suspect, and there'll be some here who would have a better understanding of it, I suspect an amount of that blowout is by reason of blowouts in departmental processing time rather than tribunal processing time. That does highlight for me that as the ART moves to be focused on a more rational and sensible management of its own functions, and as the President articulated, one that is common across jurisdictional areas, a real issue is likely to arise in Social Security and in other jurisdictional areas if there is not also close attention to the linkages with individual departments and review systems, and if the Parliament is not prepared to support the Tribunal with specific provisions which ensure that ministers and secretaries can't game the system by imposing delays or otherwise causing difficulties. Can I then just make a couple of other observations? The first is the attorney has rejected a recommendation of the Robodebt Royal Commission, or an observation that Section 34 of the FOI Act dealing with the Cabinet documents exemption should be repealed. I can understand that rejection in the sense that it seems to me that the Royal Commission's report doesn't support a recommendation that goes quite that far, but it most certainly supports a conclusion that that exemption should be narrowed so as to not exempt documents which disclose proposals for systemic illegality. And there cannot be a sensible rationale for it extending that far. The rationale of the exemption is to protect the confidentiality of deliberations in Cabinet so that there might be free deliberation. But not since Whitlam lost against Mr Sankey in the High Court have ministers in Australia had any expectation of the maintenance of confidentiality where the question of the legality of their conduct in Cabinet has been an issue. And so by Section 34 exempting a document because it's a cabinet document, even if it discloses illegality, let alone systemic illegality, it protects an interest which cannot exist. No cabinet minister could rationally think that they could have a discussion in cabinet about the potential commission of a crime and that would remain confidential. But as also, once you've had the Robodebt experience with the Robodebt report, the proposition that we would maintain the exemption extending as far as it does, when we now know there has been at least one occasion of deliberate and knowing proposals that the government would engage in a systemically illegal scheme. The balance of public interest, it would seem to me, is very clear in making it clear to ministers that if ever you do it, it may become public. And just as the gaming that I suspect would not have occurred had the AAT been able to make it public, even earlier, had there been the risk of it becoming public if you put it to Cabinet, I suspect would have been a reason that it would not have ever been put to Cabinet. I think that's all that I should say given my time, and I'll yield to Ruth.
Associate Justice Robert H. Jackson of the United States Supreme Court once described the advocate as the guardian of our civil liberties, observing that the rights of clients, like the liberties of our people, are only those which some lawyer can make good in a courtroom. My topic today concerns the role of advocacy in administrative decision-making as against decisions reached on the papers. It was a topic suggested to me by Professor John Jurians. Asking the president of one of our regional bar associations what the role of the advocate is risks provoking the very simple answer, a very, very important one. But my approach will be a little more sophisticated than that. I propose first to motivate the issue of advocacy in the present context by indicating that it has a particular relevance to the proposed Administrative Review Tribunal as fashioned by the suite of legislation introducing it. I'll then provide a brief conspectus of the acknowledged benefits of an oral hearing and advocacy within the common law system. And I'll then consider the particular advantages of advocacy in administrative and particularly merits review matters, and come at the end to certain issues of orality as opposed to advocacy, as they concern individuals affected by or engaging in the tribunal's jurisdiction. The present relevance of advocacy emerges from the scheme of the Administrative Review Tribunal Bill 2023 at different levels of generality. At the highest level of generality, the ART Bill includes general principles relating to proceedings to ensure that they are fair and just. Clause 9, which was briefly summarised by Justice Kiru earlier, supplies the following conjunctive objectives. The tribunal must pursue the objective of providing an independent mechanism of review that A, is fair and just, B, ensures that applications to the tribunal are resolved as quickly and with as little formality and expense as a proper consideration of the matters before the tribunal permits, and is accessible and responsive to the diverse needs of parties to proceedings, and improves the transparency and quality of government decision-making, and promotes public trust and confidence in the tribunal. Guiding principles grouped in this way, familiar from overarching purpose provisions, such as Section 37M of the Federal Court of Australia Act, and not least from clauses that we now understand were drafted by Tom, create a multifactorial conception or strategy of justice. They also implicitly anticipate a future need to counterbalance the principles, weighing one more than the other in certain circumstances. Insofar as concerns the role of advocacy, an immediate potential tension is apparent between, for example, the emphasis on expedition in subparagraph B and the focus on fairness and responsiveness to the diverse needs of parties in subparagraphs B and C. At an intermediate level of generality, as the Bill's Digest notes, Part 4 is central to the ART Bill setting out a standardised hearing mechanism for the Tribunal. While many of the provisions are equivalent to the AAT Act, there are also substantive changes aimed at providing a balance between fairness to applicants and the avoidance of rigid legal processes. There's more flexibility in hearings. Decision makers can elect not to be parties in certain circumstances. Applicants have the right to be represented, and the Tribunal may appoint litigation guardians and interpreters where needed. The provisions include uniform notification requirements and standardised time limits. And the Tribunal is required to provide reasons for decisions, with greater scope for publishing decisions. At a level of particularity, the proposed legislation for the ART provides for the review of decisions on the papers and without an oral hearing in various ways. Currently, under the Administrative Appeals Tribunal Act 1975, the circumstances in which an oral hearing may be dispensed with are prescribed in section 34 J. That relevantly limits the circumstances in which an oral hearing may be dispensed with to matters in which it appears to the Tribunal that the issues for determination on the review of a decision can be adequately determined in the absence of the parties and the parties' consent to the review being determined without a hearing. In the Social Services and Child Support Division, the consent of an agency party is not required. In the Migration Review Division, the AAT can decide a matter on the papers if the Tribunal considers it should decide the review in the applicant's favour on the basis of the material before it. The applicant consents to the AAT deciding the review without the applicant appearing, or the applicant is invited to give information that is relevant to an application and the applicant fails to do so. That's by reason of sections 360 and 425 of the Migration Act 1958. The ART Bill proposes certain changes to the Tribunal's powers to dispense with the requirement for an oral hearing. Those changes are proposed bearing in mind certainly of the objectives of the new ART, to which I've already adverted, along with an applicant's right to present their case to the Tribunal. As I've noted, Clause 9b of the Bill provides that the Tribunal is to provide an independent mechanism of review that ensures applications are resolved as quickly and with as little formality and expense as a proper consideration of the matter before the Tribunal permits. The explanatory memorandum to the ART Bill states at paragraph 231 that this objective is supported by, among other things, expanding the circumstances where a matter can be resolved without a hearing. The ART Bill also proposes to retain an applicant's statutory right to present their case, which is currently found in section 39 of the AAT Act. The statutory right of an applicant to present their case under the ART Bill is contained in clause 55, subsection 1A of which relevantly provides that the Tribunal must ensure that each party to a proceeding in the Tribunal is given a reasonable opportunity to present the party's case. Now, while clause 55 does not mandate an oral hearing, it supports an approach whereby, other than in circumstances where the Tribunal may dispense with an oral hearing will be provided. The circumstances in which it is proposed that the ART may dispense with an oral hearing are set out in clause 106 of the Bill. The now expanded range of circumstances in which the ART may reach its decisions without an oral hearing include if the parties consent to it, if the only parties to the proceeding are the applicant and the decision maker is a non-participating party, and the decision is wholly in favour of the applicant, or the applicant requests the Tribunal make its decision without holding a hearing, or if a party to the proceeding fails to comply with the Act or a Tribunal order, or finally, if a party to the proceeding other than a non-participating party fails to appear at a case event, for example, a directions hearing, despite having received appropriate notice of the case event's time and place. Clause 106, as presently drafted, places a revealing emphasis on issues of consent and default. The emphasis on consent implicitly recognises the perceived inherent value of an oral hearing. That is, it is something that must be waived. The emphasis on default reveals that it is something that can also be forfeited, where the competing demands of expediency and fairness to all parties operate to strip a party of that option. Importantly, the ART's power to dispense with an oral hearing under Clause 106 of the Bill is discretionary. Before exercising the power, the tribunal must first consider the documents and things given to it in relation to the proceeding. It must also presumably take into account an applicant's right to present their case, and that the task of the tribunal in conducting merits review is to make the correct or preferable decision. And it can also be noticed that by reason of Clause 103 of the Bill, the ART may make a decision without an oral hearing if the parties agree on the terms of a proposed decision and the tribunal considers that the proposed decision is within the powers of the tribunal. That is, in effect, a consent decision. The scheme for oral hearings in the ART Bill can be contrasted with the very different scheme under the Migration Act relating to the review of decisions by the Immigration Assessment Authority. Part 7AA of the Migration Act confers jurisdiction on the IAA to review a fast-track reviewable decision referred to it by the Minister. Fast-track reviewable decisions are decisions made by the Minister for Immigration or a delegate to refuse to grant protection visas to certain applicants. The scheme established by Part 7AA imposes a duty on the IAA to review the fast-track reviewable decision by considering the review material provided by the Secretary without accepting or requesting new information and without interviewing the referred applicant. However, that is subject to the IAA having limited powers to get, consider and give new information in specified circumstances. The review by the IAA of fast-track reviewable decisions under Part 7AA of the Migration Act provides a convenient point of transition to talk about the benefits of oral advocacy in the common law tradition. Can I then collect certain recognised, if non-exhaustive, virtues of advocacy in the common law tradition, beginning with the relationship between bench and bar, and coming then to the relationship between the parties and the court or tribunal? First is an observation made by Justice Antonin Scalia in his book Making Your Case, that advocacy, and especially oral advocacy, is apt to assist a decision maker who is undecided at the time of a hearing, particularly in a close case. Scalia considered that oral argument could furnish a perspective which written material could not. Second, oral advocacy is more likely than written advocacy to change a decision maker's mind once provisionally formed. And so Lord Justice Laws in St Gupta and Holmes, 2002, England and Wales Court of Appeal, Civil at 1104, paragraph 38, said this: oral argument is perhaps the most powerful force there is in our legal process to promote a change of mind by a judge. That judges, in fact, change their minds under the influence of oral argument is not an arcane feature of the system. It is at the centre of it. It is a commonplace for a hearing to start with a clear expression of view by the judge or judges, which may strongly favour one side. That means that the advocate knows where he is and the position he has to meet, and he often meets it. Third, oral argument allows an advocate to observe what appears to be of particular interest to a decision maker, and then to shape her or his argument to address those issues. And so, as Justice Brennan of the United States Supreme Court said in Goldberg and Kelly, 397 US 254, moreover, written submissions do not afford the flexibility of oral presentations. They do not permit the recipient to mould his argument to the issues the decision maker appears to regard as important. Particularly where credibility and veracity are at issue, written submissions are a wholly unsatisfactory basis for decision. Fourth, and relatedly, oral hearings facilitate dialogic discussion between the decision maker and the parties through their representatives. As the Honourable Susan Kiefel AC KC observed, advocates may be interested in persuading judges, but judges are more interested in ascertaining the correct answer, which requires the refinement of the real questions in the case and the consideration of different possible approaches. This may often be assisted by dialogue between counsel and the bench. It can be noticed, of course, that this dynamic works in both directions. The advocate can perceive what matters to the decision maker, but can also try to redirect the decision maker to what the advocate believes truly matters in the case. Dyson Heydon made the related point that there can be a freshness and vitality in oral presentation of a point which is missing when the point is advanced in writing alone. A new angle of vision can improve the view. Fifth, when combined with and subsequent to written submissions, oral advocacy can have a benefit also described by Dyson Heydon in these terms. Written submissions encourage a more free-moving approach in oral argument. For example, formerly, when argument was purely oral, a difficult tactical question could arise if a judge asked a question which, if answered there and then, would involve a departure from counsel's preferred order of address. If good written submissions had been filed, it is safer to answer the question immediately, briefly or not so briefly, and depart from the preferred structure, for counsel can be confident that that structure is already lucidly explained in the written submissions. Six, there may be circumstances in which there is inherent institutional value in a particular matter being heard publicly. Seventh, and significantly, an oral hearing may meet the need in respect of certain kinds of disputes for persons to experience the process such that they feel that they have been heard. This was described by the House of Lords in SHD and AF number 3, 2009 United Kingdom House of Lords 28, as aimed at avoiding, and I quote, the feelings of resentment that will be aroused if a party to legal proceedings is placed in a position where it is impossible for him to influence the result. Eighth and finally, as observed by Lord Reid and Osborne and Parole Board, 2013 United Kingdom Supreme Court 61, and I quote, justice is intuitively understood to require a procedure which pays due respect to persons whose rights are significantly affected by decisions taken in the exercise of administrative or judicial functions. Respect entails that such persons ought to be able to participate in the procedure by which the decision is made, provided that they have something to say which is relevant to the decision to be taken. Among the virtues that I've collected, certain points resonate in the context of merits review in a tribunal, such as that envisioned by the ART bill, and bearing in mind that there will be a mix of adversarial and inquisitorial hearings in that tribunal. First, the tribunal is seeking to identify the correct or preferable decision. Continuing the observation of the Honourable Susan Kiefel AC KC, which I quoted from earlier, Her Honour continued as follows. It can hardly be doubted that the opportunity for dialogue is of benefit to judges. It allows for fuller explanation of the facts, reference to the evidence. It permits discussion of the approach taken in the argument. It may elicit a more direct answer to different approaches to an issue. It allows for the resolution of uncertainties about what was said in written submissions, and it allows arguments to be tested. In short, it is essentially apt to facilitate reaching the correct or preferable decision. Secondly, the flow of advocacy may be better suited to bringing out an error of fact or law upon which a decision maker might otherwise act. And that will be especially so where fine-grained factual matters may be determinative of an outcome. Third, where a panel of members is sitting, as will often occur, there may be particular value in the dialogic testing of points, not only to be tested between the advocate and a judicial or non-judicial member, but among the members themselves, precipitating different points of view from the perspective of different fields of expertise. Fourth, and importantly in the context of the ART, there will be disputes where it is important for persons to experience the process such that they feel that they have been heard in the decision-making process. That point has been put differently by the Honourable James Alsop, AOKC, in a passage which I think should be read to each barrister when they commence practice at any of the bars. Independence and the degree of abstraction within it involves the recognition of the significance of the dispute to the lives of the humans involved. Every advocate and every judge should be conscious that what might seem a routine or banal case may represent the most significant and potentially catastrophic event in the lives of the people involved. The judicial process ought to impress this upon one on a daily basis. Fifth and finally, there can be a quite different occasion where orality, as opposed to advocacy in the traditional sense, will be critical. The April 2023 Administrative Review Reforms issue paper, which preceded the recent legislation, noted this at page 58. Oral applications are a long-standing feature of social security review. The SSCSD often engages with vulnerable and disadvantaged individuals. Oral applications help make the AAT more accessible for those applicants. Oral applications can also be useful in ensuring a robust application, as a tribunal officer can immediately seek further information or assist to redirect an application if the person is not or not yet eligible to seek AAT review. This must be balanced with the extra resourcing required in the AAT that enables the oral application to be taken by a tribunal officer. The disadvantages imposed by formality and by processes essentially predicated on literacy will produce circumstances where individual applicants should be permitted to appear personally, to make oral submissions with the benefit of a tribunal assisting them to understand the processes to which they are subject, the outcomes that might occur, and the implications for their lives of those outcomes. Those needs are called up by clauses 9A and C of the ART Bill, that the processes be just and fair and accessible and responsive to the diverse needs of parties to proceedings. Legal processes can be foreign and intimidating things for many people. It is an ineliminable aspect of the duties of all officers of the court to strive to make the law intelligible, navigable, and ultimately felt to be fair for all those required to utilise it, and particularly for the party who loses. An essential aspect of that will be creating a circumstance in which individuals believe that they have been attended to honestly and genuinely and heard. And that will often require an oral hearing. So I've come to the conclusion with which I began, that advocacy is very, very important. Thank you. Justice Hesby earlier kindly answered one of the questions that was directed to me, and which I hope I have now answered in my talk, which is what is the role of the advocate in influencing the outcome of administrative decision-making processes. I hope I have answered that.
There's a question to me, I think, of National Legal Aid has recommended that the proposal to end the 2 tiers for social security be either removed from the bill or paused until the full range of reforms re social security are completed. Do you agree with that recommendation? To which my answer is, I don't know. I haven't been involved in a social security review for 30 years. What's clear from the record is that the AAT now conducts single-member hearings. What's clear from what the President has said and what the Attorney has said is the members to do that are to be chosen by some notion of merit, where the merit seems to be around generic capacities to conduct merits review. It's not clear to me that that's necessarily directed to a skill set which will be most effective for a whole range of social security reviews. But if single members are conducting reviews, at the moment through a two-tier system, intuitively, even without the benefit of a Section 193, the first-tier reviewer is likely to be prepared to work a bit more quickly and with a bit of a greater preparedness to accept the risk of error, knowing that there can be an application to have it looked at again on a merits basis if they get it wrong. So that if you remove the second tier, it does seem to me it runs the risk of slowing down the only review that will occur and making it more formal. And if the reviewers are people whose skill set is not particularly appropriate to the particular reviews, then those risks seem to be greater. What I wouldn't do is what is then by way of follow-up to this question, which is to indicate that the question comes from the National Legal Aid submission to the Senate committee, where the two-tier model allows the legal assistance sector to target high-intensity legal assistance services at a much smaller number of matters that proceed to Tier 2. From my experience with the child support scheme that I'll come to, I think you put the cart before the horse if you design any form of decision-making system by reference to what impacts it might have on legal aid. I think legal aid, certainly there needs to be consultation and there needs to be time for it to be worked through, and it might need some more dollars for legal aid, but legal aid's job is to assist people navigate a system which is designed to do the job as best it can be done for the people. The system ought not be designed to facilitate legal aid.
So there's a question for me from someone who wishes to remain anonymous. It would be a rare person who would dispute the value of advocacy. How do we afford it in tribunals where the primary users are citizens who are rarely entitled to legal aid? Can I answer that question in two ways? First, there's an important distinction which I tried to bring out in the talk between advocacy and orality. There will be applicants who cannot afford professional advocates to represent them. There is a different question as to whether, even notwithstanding that, appearance by that individual themselves and orality in that sense in a hearing is appropriate. Some of the factors about advocacy that I mentioned towards the end, the importance of a person feeling they have a say in a process that has serious ramifications for them, the importance of felt fairness and the like, is equally manifested by an individual representing themselves and hopefully having a tribunal member explain to them the adequacy of the material they have, listening to the representations they've made and reaching a decision. The second issue that arises from the question in terms of cost is a broader one, I think, as to any administrative tribunal which will confront already a substantial backlog, a vast burden of work, and there are issues both of cost and time in the holding of oral hearings in those circumstances. It is interesting that Clause 106 expands the circumstances in which oral hearings can be forfeited beyond the current Act, and it more obviously picks up and begins to weigh the tension between the various objectives in Clause 9 of expediency and timeliness and fairness to the parties. There are, in Clause 106, clearly marked circumstances of forfeiture of the right of an oral hearing, and that, I think, is already a legislative acknowledgement that there is a limit on the availability of money and of time in these kinds of matters.
Does the panel think that the public service is open to being guided by the tribunal in respect of good decision-making, and what might come of such a normative or thought leadership role for the tribunal going forward? My short answer is not much. But I think that's a two-sided thing. The most public service agencies are very well resourced and resourced by very clever and well informed people. And most of them now have very large legal units. And one of the key gatekeepers generally to the thought of agencies on any matter of law is the General Counsel of the agency. The Robodebt Royal Commission and the cross-examinations of Annette Mussolino, who was the General Counsel and then a Deputy Secretary, is very, very informative on that, where even with a change of secretary to someone who had been an eminent public lawyer before she was the Secretary of the Department, it was the General Counsel who, for the space of about 8 months, kept the Robodebt scheme going by effectively managing all the briefings to the incoming secretary in a way which was, the Commission found effectively was to protect Ms Mussolino from the consequences of her earlier involvement with the earlier secretary. So I think there's, on the public service side, it's the rare agency and the rare issue where there will be openness to thought leadership. But I think on the tribunal side as well, frankly, it's hard to think of many decisions of the tribunal in the last 10 years across any of the areas I've practiced in, where you read them, where you think there's real insight there to be had. There are some in the tax area, and clearly the tax office does benefit from and take account of, particularly questions around transfer pricing or trusts and so forth, where you do get some much higher levels of expertise on the AAT than you would get in the tax office. But other than those areas, I can't think of an AAT decision, as I say, for probably 10 years, where you think that really has some real insight as to how you might approach this area. And I think that's a challenge for the new leadership of the ART, and for the Guidance and Appeals Panel. And I think it's a challenge made much harder by the extraordinary backlog of work which they're going to have to manage as they crank it up.
Okay, I'll do one final question and then release you into the drinks and canopies. There's a question: given the importance of advocates and the significant power imbalance between parties in an ART dispute, do you think there's a need for accessible advocates at the ART? There are at least two ways in which that could be facilitated. One would be an institutionally specific provision of advocates. That would be anomalous. I'm not aware of any jurisdiction that does that. And it would be a matter for the Parliament whether it was appropriate here. There is, however, a different means, and that is general referral schemes which are instituted and maintained by various law societies and bar associations. For example, New South Wales Bar Association has a scheme, LARS, which is a referral scheme to which barristers sign up, and their name is on a list that people can contact for representation where they're otherwise finding it hard to find a representative and have it on legal aid terms or otherwise. So it might be that those schemes should be advertised at the premises of the ART across the country, so that applicants and others attending at the premises who want representation but can't afford it at least have brought to their attention the various schemes that law societies and bar associations operate. Because the short answer to the question, I think, is yes. Accessible advocacy and general accessibility of justice is imperative, but it might be that the best way we can do that is by publicising existing schemes so that applicants find out about them.
On behalf of Norton Rose Fulbright and everyone attending today, I'd like to sincerely thank the Whitlam Institute, the Honourable John Faulkner, Professor John Durrance and Western Sydney University for facilitating such a great topic today and assembling such distinguished speakers. The Attorney-General, the Honourable Mark Dreyfus, KC MP, the Honourable Justice Emilios Cairo AO, Honourable Justice Lisa Hesp, Ruth Higgins SC, Tom Brennan SC. Sometimes it takes the unearthing of a structural defect causing reprehensible harm, such as robo-debt, for reforms to be made. We hope the ART legislation is passed as soon as possible and the tribunal can get on to doing their very important work soon. Thank you.